Seconds, and then our hearing can commence. The International Criminal Court is now in session.
Hi, good afternoon, everyone. I'm Judge Natalia Silva, and today I will be presiding this hearing. The judges joining me are Judge Klaus and Judge Kremer. First of all, I would like to welcome the teams of this Nuremberg Moot Court competition, the counsel for the prosecution and the counsel for the defense. On behalf of the chamber, I will now ask the parties to introduce themselves and to explain how are they going to allocate their time. Counsel for the prosecution, please introduce your members.
Good morning to your honors and the defense bench. The prosecution in the case against Mr. Blaze is represented by my co-counsel Garce and me, Felipe Mendoza.
Thank you very much. I now will turn to the counsel for the defense, please.
Good morning, Madam President, Your Honors. The counsel for the defense is represented by Sam Lubner and Daniel Mullen, and we will aim to speak for 12.5 minutes each.
Okay, thank you very much. I will now give the floor to the counsel for the prosecution for the pleadings. Please proceed.
Your honors, may it please the court. In the proceedings that we address today, prosecution versus Lord Blaze, the Office of the Prosecution sustains that there are reasons to believe that crimes under the jurisdiction of the court have been committed in the territory of the foreign nation. Specifically, crimes against humanity of enslavement under the superior responsibility of Lord Blaze were committed against families, women and men belonging to the national minority of earth powers. The prosecution will address its argumentation in 4 main points. I will address first that the court has jurisdiction over the crimes committed, and second, that the case is admissible, and my co-counsel will make submissions on the issue of interest of justice related to this case, and the superior responsibility of Lord Blaze. Turning to the first issue of jurisdiction, the court shall satisfy its jurisdiction over the temporal, territorial, and personal rationes. The preconditions for these are fulfilled in a specific case, and the prosecution will address the ratione materiae, since its contextual and specific elements deserve a detailed examination. Regarding the contextual elements from the footage, testimonies, and evidence brought before the court, it is unchallengeable that the earth powers were continuously subjected to illegal detentions, restrictions on their basic freedoms, and stigmatizations. In mid-2018, even before Mr. Blaze's executive order and the opening of the 40 so-called education centers, tens of thousands of earth powers, a civilian population, were detained for exercising their right to freedom of assembly and association on December 2018. This constitutes an attack under the terms of Article 7.1. Once detained, the reason or length of the detention was not provided. Identity documents were confiscated. Detainees were forced to endure long hours of work, and refusal to work was brutally punished. The prosecution submits that there was a preconceived strategy that promoted and encouraged the attack directed against the earth powers. Such strategy took the form of a policy implemented by Lord Blaze in his decisions, coordinated with its subordinates and the BNS, with profiting of the governmental hierarchical structure and with public resources, to monitor and control the extensive worksheets to forcibly build and repair cars without compensation. The policy outcome was none but to subject the earth powers into enslavement and profit from the labor force. Additionally, the prosecution submits that the nature of such attack was widespread and systematic. Stated before, it targeted tens of thousands of people. Only in Ring Center, 100,000 air powers were brought. The powers attached to the right of ownership over all of these women and men started with the detention and continued at least until their release. And if not limited to a geographic or quantitative criterion, it is reasonable to believe that a similar modus operandi occurred in all the other 39 centers around the country. The random occurrence of these facts is most improbable. They repeated at least 100,000 times in Ring Center. The patterns and scale also show that the acts committed were part of an attack directed against the civilian population. Discriminatory measures like prohibiting children to use their own language in schools and the arrest and detentions of Earth Power priests existed before the attack and started soon after Mrs. Blaze's election. There is therefore a reasonable basis to determine that the acts of enslavement attributed to Lord Blaze were part of a widespread and systematic attack against the Earth Powers, and that such attack was done with knowledge. Let me refer.
Can I just interrupt here? You keep connecting the enslavement to Lord Blaze. On what evidence do you rely to make Lord Blaze accountable?
Thank you, Your Honor, for the question. It is true that the prosecution right now counts primarily with one direct witness. We also count with indirect witnesses, such as families from the Earth Powers that had to flee from Fire Nation, and with contundent evidence as well, like footage and the reports from journalists. Besides of that, we support that the policy implemented by Lord Blaze had as well the purpose to create fear among the Earth Powers. We support that this fear created among the Earth Powers was also encouraging them not to come or not to be part or testify directly. We also support that this trial can provide visibility enough to raise the concern that this is a grave crime and that victims should trust in the justice imparted by the ICC.
But how can you rely on people refusing to testify if you're the prosecutor with the onus of proof?
I'm not relying on the witnesses right now. We're relying on the evidence that we have in this moment. And we will provide.
You only have one live witnesses as to what happened on Center Rig. And that live witness was a former member of the AANG who escaped. How do you justify giving his testimony any credibility?
Your Honor, thank you for the question. The witness we sustain is truthful, credible, accurate, and reliable. The testimony he gave is detailed, candid, comprehensive, and specific. It shall be considered that the witness testifies about its personal experience and consequently has no impacting the truthfulness of the evidence. It shall have a probative value. This has been addressed in ongoing case in paragraph 2066 and 2088. Besides that, following the example of prosecution versus Tadic.
One question. You mentioned the policy of the crimes against humanity, of the crime against humanity. Could you please explain to me what the policy is in this case and whether or not it was officially formulated and if it has to be officially formulated or not?
Yes, Your Honor, thank you for the question. The policy doesn't have to be officially formulated. In prosecutor against Bemba, there were considered factors to infer the policy. Such factors contain that the attack was planned, directed, or organized. A second factor is the recurrent pattern of violence. A third one would be the use of public or private resources to further the policy. The fourth one would be the involvement of the state forces in the commission of the crimes. A fifth one, that statements, instructions, or documents attributable to the motivation, attributable to the state or organization condoning and encouraging the commission of the crimes, and as well an underlying motivation. We submit that all of these requirements were fulfilled in the case that we're addressing in this case before trial. May I continue?
Yes.
Thank you. Thank you, Your Honor. Let me refer to the material elements. As I just mentioned, the exercise of any or all of the powers attaching to the right of ownership over one or more persons is a definition that currently is determined by the elements of crimes regarding Article 7.1c. This includes forced labor. Pursuant to the indicia established in Cunarak from the ICTY and followed by the Taylor case, and most recently in prosecution against Unwin, the prosecution here sustains first that the Earth Powers were illegally detained and brought to the Island Fortress Street Center. Second, the island was heavily guarded, surrounded by security walls. Third, the length of the detention wasn't communicated. cultural practices, and the use of the language was forbidden. Fourth, refusal to work or weakness was punished. Fifth, arrest and detention spanned the course of many months, almost a year. Sixth, punishments consisted of standing outdoors in degrading conditions. And seventh, forced labor included without rest 12-hour shifts per day, every day. Although a non-exhaustive list, let me refer to the Paul case highly quoted. We might eliminate all proof of ill treatment, overlook the starvation, beatings, and other barbarous acts, but the admitted fact of slavery, compulsory and compensated labor would still remain. The earth powers detained were factually given no other choice. Regarding the mens rea elements, the circumstantial and...
Sorry, before you move on, let me interrupt you here.
Yeah.
So you're relying on forced labor as being a form of enslavement here. I'm sure you're aware of footnote 11 of the Elements of Crimes, where it says that in some circumstances, exacting forced labor may be enslavement. So what are these in some circumstances? Can you give us a more abstract definition of that as well, or do you contend that it is just a you know it when you see it standard?
Thank you, Anna, for the question. When I addressed the 7 elements, I was indicating the criteria established to determine enslavement. These are the circumstances that determines where the elements of enslavement have been fulfilled. Additionally, I want to address that yes, enslavement is a type of slavery, and therefore it fulfills and is inside the definition followed by the Slavery Convention of 1929 and the Supplementary Convention of the Abolition of Slavery and Slave Trade. I can extend in the answer if you want.
No, it's fine. Please proceed.
Thanks. The mens rea, regarding again to the mens rea element, the circumstantial and direct evidence are fulfilled, as I just said. My colleague will extend this point before concluding with submission. Turning to admissibility, the case does not fulfill the conditions in Article 7.1c of the statute regarded as inadmissible. The Truth and Reconciliation Commission has the obligation of establishing the truth of the conflict, and it was tasked with publishing a report for which no information has been provided. According to Article 1 of Law Number 14, all ongoing investigations and prosecutions will be terminated, and any criminal sanctions will be revoked. This indicates no intention to actually investigate crimes, and even less to prosecute the responsible, as indicated in Article 23. The requirements stated in law number 14 demanded a public apology to the victims, which does not require acceptance of guilt or confession of any crimes. Relevant elements in any actual judicial proceeding would be a confession at least. Such norms and procedures established were conducted as stated in Article 23b in a manner which, in the circumstances, was inconsistent with an intent to bring the person concerned to justice. Now, to anticipate the defense arguments, the amnesty granted to Mr. Blake cannot be invoked before the ICC to declare the case inadmissible. The emphasis of the preamble of the statute on accountability of perpetrators of such grave crimes suggests that deferring prosecution because of amnesty would be incompatible with ICC's purpose. Again, proceedings have not taken place in private public, and if they had, Article 1 of the Law Number 14 terminated them and revoked their sanctions. Truth and Reconciliation Commission is not a court, and the judicial process established in Law Number 14 is simply to verify the fulfillment of disarmament and a public apology. Scholars' opinion and international jurisprudence assert that customary international law prohibits amnesties for these cases and requires prosecution. Due to a growing recognition that the state's duty to ensure rights implies a duty to hold specific violations accountable. The ICC should focus on leaders who bear the greatest responsibility. As president, Mr. Blaze should therefore first should not be subject to an amnesty exception. And there does not exist any investigation or procedure with intent to bring the perpetrators to justice, and victims' rights would be violated if the perpetrators are not prosecuted. Our republic has the duty to investigate and punish the perpetrators of grave crimes. Its unwillingness has shown that that has not been the case of Mr. Blaze. Prosecution of the individuals who committed international crimes can facilitate reconciliation and national building. Therefore, an amnesty like the one granted to Mr. Blaze, without any real investigation and accountability for the crimes committed, can and will not contribute to the peace-building process in the Far Republic. The ICC...
Counsel, sorry, I have to interrupt you here. Are we and you really in a position to decide that? Isn't it rather something that a people and a nation have to decide for themselves and in their interior sovereign procedures? You know that this court is a treaty-based court, also based on complementarity. So intrinsic to our Rome Statute is a certain respect for nations, for their people, for what they decide is best for them. And as we've seen in the past in some countries, truth and reconciliation processes without strict criminal prosecutions can be successful. Maybe you have a couple of examples for that you can mention to us, or counter examples. So is it really upon us to decide that, or don't we have to respect the national amnesty proceedings?
Thank you, Anna. I would like to refer firstly to the preamble of the Rome Statute that affirms that most serious crimes must not go unpunished, determine the end of impunity, and recall the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. According to the Article 31 of the Vienna Convention of the Law of Treaties, each state has the duty to interpret and to apply these treaties that it's bound to in a good faith. Second of all, I would like to refer to the case law of the Inter-American Court of Human Rights regarding, like, respect as well to Article 21.3 of the ICC of the Rome Statute. This case law that I will submit here is extensive, but I can go forward, like, if you ask for it. I have, like, we submit the case Almonacid Arellano and others against Chile, the Masacre Popiripan against Colombia, the Caso Contreras against El Salvador, Caso Masacres y El Mazote en lugares aledaños against El Salvador, well, en Barrios Altos against Peru. Your Honors, the interpretation of the whole Inter-American Court regards the implementation of amnesties in several states. As we submit, it is the place, especially before this court, to determine that an amnesty should not be given to avoid prosecution. I'll give the floor to my counsel, Mr. Zeh. Thanks.
Thank you, Your Honors, and may it please the court. I will now briefly address the issue of interest of justice before moving to our final submission on the superior responsibility of Mr. Blaze. It is our respectful position, Your Honors, that this hearing has no statutory basis to consider this issue of interest of justice in its deliberations. Article 53 of the statute includes interest of justice as a criteria for the prosecutor to consider in cases referred by the Security Council or state parties, such as the case before the court today. However, as per Article 53.3, it is only if the prosecutor decides not to proceed on the basis of interest of justice that judicial review of such a decision would be permitted. There is no obligation on the prosecutor to affirmatively prove that an investigation would in fact be in the interest of justice. We will also note this court's ruling in the situation in Afghanistan case, where the appeals chamber determined that the pretrial chamber had erred in considering the interest of justice where it had no basis to do so. In our view, this case very much serves the interests of justice, including based on explicit criteria of the gravity of crimes, interests of victims, and circumstances of the accused. However, given our position that this determination should not be reviewed by this chamber, and in the interest of time, I will not at this time detail these merits further, but invite your honors to ask for further explanation if so desired. With that, your honors, I will move to our final submission, and that is in regarding to the criminal liability of Mr. Blaze, specifically as found in Article 28B of the statute. My co-counsel has already established that the underlying crime against humanity of enslavement was committed at Center Rig. The remaining question then is whether Mr. Blaze bears criminal responsibility for these crimes as a superior. We will demonstrate how this case meets the required elements by showing that he exhibited the required authority and control, had the required mens rea, and failed to take all reasonable and necessary measures to prevent and repress the crimes. First, Mr. Blaze was in a superior subordinate relationship with effective authority and control over the subordinates and the crimes they committed. Such a relationship of superiors can be both de jure or de facto in nature. And this relationship between the superior and subordinate need not be direct, but can go through multiple levels of a hierarchical structure. In this case, Mr. Blaze had a high-level de jure official position as president of Fire Republic. His clear ability to give orders is evident by the executive order that he issued requiring BNS to use the necessary means to end threats to national security. This was the source of authority under which the detention centers were opened. The executive order also demonstrates the superior subordinate relationship, which included direct reporting from Ms. Azala, who personally oversaw the education centers, as well as establishing a relationship between Mr. Blaze and the BNS agents at Center Rig who committed the crimes. A key consideration for superior responsibility is the power to control the acts of the subordinate. And effective control will be established when indicia demonstrate a material ability to prevent or repress crime and submit it to the authorities for investigation. A finding of effective control will always be case specific. However, relevant factors as identified in the Bemba decision that indicate effective control include such things as the official position of the superior, their ability to issue orders, the nature of their orders, and their capacity to ensure that the orders are followed and executed. In this case, Mr. Blaze had a high-level official position as president of Fire Republic. He clearly had the ability to issue orders as demonstrated by the executive order, and to ensure that the orders were executed, as can be seen by the regular reporting required to him by Ms. Azila. In addition to the written report that was ordered, the communications in Exhibits 1 and 2 show a clear pattern of regular communication between Mr. Blaze and Ms. Azila. He also had significant direct involvement with what was happening at the detention centers, including the ability to send more people and supplies. And this is also aptly demonstrated his involvement by his order to release some of the detainees. Finally, we submit that Mr. Blaze had the capacity to refer such a matter to the competent authorities for investigation, and therefore this establishes his superior subordinate relationship with effective control. Second, I will now turn to the fault requirement for superior responsibility as established in Article 28E. And this includes both knowledge or a conscious disregard of information clearly indicating that subordinates were committing crimes or about to. There is substantial evidence, I submit, in this case that Mr. Blaze did in fact clearly disregard information indicating that crimes were being committed. This standard of willful blindness requires information indicating a significant risk that crimes are being committed. The information is available to the superior, and while the superior is aware that the information existed, declined to refer to this category of information. As we can see in Exhibit 1 and 2, Mr. Blaze was already aware in December 2018 and early January 2019 of key indicators of the nature of what was happening at Center Rig, including that detainees were performing labor. A key phrase that I ask your honors to consider from the phone call transcript is when Ms. Azala says, quote, "We might need more men," to which Mr. Blaze replies, "I will see what I can do." And I ask this court to seriously consider whether such a request and response really fits in line with this suggestion that what was happening at the camps was indeed only for educational purposes, as is claimed. I respectfully submit that this transcript, as well as Exhibit 2, the official correspondence, is part of how we established that Mr. Blaze clearly disregarded this information. This is further supported by the public report published online by Journalists for Human Rights, which clearly detailed that crimes were being alleged, with an interview of a former detainee and photos supporting the allegations. Such evidence shows that there are reasonable grounds demonstrating that Mr. Blaze had the necessary fault requirement to be criminally responsible as a superior. And on this note, I just want to return to your honor's question previously about how this case is obviously the evidence is largely supported by one witness, as well as a lot of additional circumstantial evidence. And what I would ask the court to remember is that at this stage, we are dealing with reasonable grounds to believe, which is a much lower standard than what will come at the confirmation of charges stage, as well as what would be required, which is substantial grounds, as well as what would come at the conviction stage, which is a reasonable doubt to believe. This is a very early part of the proceedings, and as established in al-Bashir, the al-Bashir case, there's reason that the standard is so low. Obviously, there's much more time that we will have to gather the required elements, and we emphasize that at this stage, the reasonable grounds means that it should be interpreted as a reasonable conclusion on the evidence. It doesn't have to be the only, it has to be a reasonable conclusion. And we respectfully submit that Mr. Blaze's knowledge or conscious disregard for information in this case meets that threshold.
Before you go ahead, I'm sorry.
No, please, you go
okay,
first.
Just a question on that. Am I correct to say that the only direct evidence that you have of Mr. Blaze's knowledge is the I'll put it differently. You have no direct evidence of Mr. Blaze having knowledge of the crimes of enslavement or the component parts of the crime of enslavement taking place. It's all an inference to be drawn from the circumstances.
It is largely circumstantial evidence, Your Honor. Again, we do submit that this meets the threshold of a conscious disregard, and especially what we see in the exhibits, especially
but to consciously disregard, you have to have something that would suggest that the data or information was available to them.
And in our respectful submission,
just let me finish.
Yeah.
When I look at the facts, what's missing is that Blaze knew that these people were enslaved. They were imprisoned. I accept that, but whether there was forced labor happening is unclear, given the information. You rely on the escaped detainee to set up the factor that that enslavement was taking place, but the question is, how did he know, or how could he have known? You're saying he must have read the report of the Human Rights NGO. I'm not sure. You know, it seems to me that aspect of your case is pretty thin.
Again, Your Honor, and I see we're out of time, Madam President. If I may respond to this last question and then summarize quickly. I appreciate, Your Honor, the issues that you've mentioned. Again, I will just reiterate that it's our position that the exhibit, especially when asking for more men, it's to me incredulous that such a request would be made if it's simply an educational purpose that this center is serving. Furthermore, there's other elements that we think in combination, and we ask Your Honors to consider the cumulative nature of the circumstantial evidence in this case. It's sure that there's not one direct thing that we can point to with certainty that Mr. Blaze had knowledge, but I think that there's enough evidence at this stage to prove that there's reasonable grounds to believe that he did in fact consciously disregard the information.
Thank you.
Thank you, Your Honors. So with that, Your Honors, I will conclude. We do respectfully submit that in this case, the onus has been met. We ask that this chamber dismiss the defense application and rule that the case against Mr. Blaze is indeed within the court's jurisdiction, that it meets the grounds of admissibility, that it is in fact not for this chamber to consider the interests of justice, and finally, that there are reasonable grounds to believe that Mr. Blaze is criminally responsible. Subject to any further questions from the bench, those are our respectful submissions. Thank you.
Okay, thank you very much. I will now give the floor to the counsel for the defense. Please proceed.
Madam President, Your Honours, This case concerns accusations of crimes against humanity of enslavement. However, the evidence in support of the prosecution's case is neither independent nor of a strong probative nature. We will submit that even by taking this evidence at face value, it cannot be said that crimes against humanity were committed, and nor that Lord Blaise had criminal responsibility. Nevertheless, Lord Blaise has worked collaboratively in implementing transitional justice and has submitted himself to a constitutional court in his own country after becoming aware of the allegations in Black Mound. I will argue that the court does not have jurisdiction to hear the case against Lord Blaise and that the case against him is not in the interests of justice. My co-counsel, Mr. Mullen, will argue the remaining grounds, dealing with the issue of admissibility under Article 17, subsection 1c, and Lord Blaise's alleged criminal responsibility. On the first ground then, the court does not have jurisdiction pursuant to Article 5 of the Rome Statute. Our position is that no enslavement took place, and if it did, which is denied, it did not meet the chapeau elements of a crime against humanity. Regarding the question of enslavement, enslavement is defined as the exercise of any or all of the powers attaching to the right of ownership over a person, and we submit that this definition does not align with the case before us. The detainee's deprivation was in accordance with international law. Article 9 of the International Covenant on Civil and Political Rights provides that no one shall be deprived of his liberty except on such grounds and in accordance with such procedures as are established by law. We note that terrorists were arrested and sent to prison for 15 months, and this was in accordance with the 2018 Anti-Extremism Executive Order, and the court will know that this was established in the wake of violent protesting in Black Mound. While in detention, detainees could elect to take part in training programs, which would lead to a short reduction in their sentence, or choose to be treated as a normal prisoner. Enslavement, by definition, requires an extreme degree of control, and we submit that these measures did not meet this requirement. And at this point, Your Honours, I will briefly address the allegations of Harry Rock, which, as my learned friends have said, provide the foundation of their case that enslavement took place. In short, they are unsubstantiated. Despite the release of tens of thousands of detainees and an amnesty that was made in collaboration with the AANG and specifically designed to protect former detainees from prosecution, there have been no corroborating accounts of the conditions in Centre Rig. And as a leader of the AANG, Mr. Rock cannot be held as an objective or independent witness, and in the absence of supporting testimony, Mr. Rock's allegations should not be treated as demonstrative of the conditions in Centre Rig or anywhere else. I will now move on to whether what happened met the elements of a crime against humanity. Our first point is that it was not a widespread or systemic attack. The elements of crimes state that for an attack to be widespread or systemic, the state must actively promote or encourage such an attack. It is therefore the role of the prosecution to show that the conduct in Centre Rig was pursuant to state policy and that the policy had the aim of harming civilians. The connection between international crimes and government policy was discussed in detail in the Rome Conference, and the decision to make this connection explicit in the statute was deliberate. Therefore, to impose liability on Lord Blaise in these circumstances would be to reject that decision. It can't be said with certainty that he was the architect of any state policy of enslavement, and while it is true that he had knowledge of prisoners working, and even we concede, in poor conditions, we haven't seen evidence that he was aware of measures amounting specifically to crimes against humanity of enslavement taking place. It therefore follows that Lord Blaise had no knowledge of the attack for the purposes of Article 7, which requires that the perpetrator must have known that the conduct was part of or intended the conduct to be part of a widespread systematic attack against a civilian population.
Counsel, sorry, I think my fellow judge also wants to ask something, right?
Of course.
Sorry, I can go ahead if you don't mind. I'm wondering about that mental element you just mentioned. because the prosecution is not charging Lord Blaze as a direct perpetrator, but under Article 28 of the Rome Statute. And they made extensive submissions on his mental element under Article 28, going for the should have known standard. So in how far does he actually have to fulfill that direct perpetratorship mental element you just addressed? What is the relationship between these mental elements, the various kinds we have in the Rome Statute there? Could you please expound on that?
Well, yes, and thank you for the question. The mental element is necessary in order to state or define that a crime against humanity has taken place. Indeed, the mental element is part of the definition. With regards to the prosecution submissions, of course, we would say that, yes, he was certainly aware of conditions in the centre rig and other areas, but this fell short of what took place, or this fell short of the definition of a crime against humanity of enslavement. May I continue?
Just before you continue, my question was related to Centre Rig. It's a facility that is more like a prison than an education center. We don't have specific evidence on the other centers and how well they're guarded and how well the people are controlled. But from the point of view of the people at Centre Rig, we had not only terrorists, but we have families and children. And to me, that evidence of 100,000 people in what appears to be a prison is evidence of an attack on a defined population, on the civilian population.
Indeed, Your Honour, we don't deny that the inhabitants of Centre Rig were detained, and they were, of course, detained under terrorism offences. Therefore, we would say it is only right that it was the centre was protected to some degree, and of course, if signs of security, such as barbed wire and CCTV cameras, were an indication of guilt or a crime against humanity, we would say then many world leaders would have to be before this court on that basis. With regard
to the terrorists were arrested, assuming that they were terrorists. There's evidence that they were terrorists because there was a civil demonstration that was broken up. And I don't know that the evidence is clear as to how many of the 40,000 arrested were actually terrorists. But be that as it may, what was my point? The individuals were never brought before a court. They were taken directly to Centre Rig and imprisoned there. Wouldn't international law require, even for a terrorist, to have judicial process to confirm that he or she fell within the terrorist definition of the local law, and they can be detained for a certain period without trial? But here, these people were detained, no trial, a sentence imposed, or a determinate period imposed without judicial process. Any rights to defense, any rights to plead a case. I'm just a child, I'm 6 years old, I shouldn't be here.
Well, on the point of families and children, of course, we would say that children up to a certain age are still nevertheless capable of committing offences. But in the interest of time, it is accepted, of course, the points you've raised about detention. However, the larger picture here is of course that only one of these elements of the crimes against humanity of enslavement have to fail in order for the whole case to fail. And if I may continue on the ground of interest of justice, Your Honour. We are grateful to our, well, I beg your pardon. On the second ground of interest of justice, the defense submits it is not in the interest of justice to proceed with the case for 3 reasons. Firstly, it would destabilize the peace process. Secondly, the gravity requirement of the crime is not met. And thirdly, that Lord Blaze played a minimal role in the events. And at this point, I say that we disagree with our learned friends that there is no basis for the interest of justice test to be considered here. The decision on the authorization of an investigation into Kenya in 2010 is precedent that all decisions of the prosecutor, especially with regards to Article 53, are subject to review by the court. Now, on the point of destabilization, the interest of justice is not defined in the Rome Statute, and the court is invited to take a broad approach here, taking into consideration wider peace and security concerns, as well as less traditional forms of justice, such as truth and reconciliation commissions. And the question is why? Because to do otherwise would be to neglect political realities. It is counterproductive to the attainment of stability and ultimately long-term justice to view international criminal law and politics as unconnected elements. And this is backed up by history, Your Honour. In 2003, the Special Court for Sierra Leone issued a sealed indictment for then Liberian President Charles Taylor while he took part in peace negotiations in Ghana. This led to the collapse of the peace talks and a sharp increase in violence, where roughly 1,000 died before Taylor eventually resigned 2 months later. Here we can see how a narrow prosecutorial position was taken, and it ended up delaying justice and failed to help consolidate peace. We also note that there is precedent for peace processes to be considered within the interests of justice test. Before issuing an arrest warrant for Joseph Kony in 2005, prosecutor Luis Moreno Ocampo noted that an indictment could be delayed under Article 53 if it is in the interests of justice to proceed with a peace settlement. And I also draw the court's attention to the appeal chamber's judgment on the appeal on the authorization of an investigation into the situation in Afghanistan, as our learned friends have mentioned. And of course, while the appeal chamber decided that the pretrial chamber had erred in the method it assessed the interests of justice test, it didn't examine the substance of the assessment itself. The appeal chamber, we note, had ample opportunity to define the interests of justice test in its ruling, but chose not to do so. So we say it's not yet a settled matter. Now, with regards to the facts of the case, the peace process has been a collaborative and peaceful endeavor. Lord Blaze implemented a Truth and Reconciliation Commission on the request of the association on the request of the AANG. There is no information of reported hostilities taking place following the start of peace negotiations in April 2019. And for this reason, we have to strongly disagree with our learned friend's submission that the amnesty has not contributed to the peace process. Law number 14, which facilitated the process, was confirmed by a constitutional court, and we submit that to start prosecution would cause unnecessary and avoidable instability, as well as undermining the democratic and constitutional processes of the Fire Republic. There is no norm against a Truth and Reconciliation Commission in international law, and should the pretrial chamber attempt to create one today, it would only encourage parties to refuse to end a conflict peacefully via a process such as this, and this would effectively defeat the purposes of the ICC. I will deal with the issue of gravity and Lord Blaze's role quickly, as I'm aware of time. In terms of the gravity of the crime, we repeat the argument on the jurisdictional ground that it did not meet the criteria for crimes against humanity of enslavement. With regards to the role, we note that jurisprudence defines those that are most responsible for crimes as those that can most effectively prevent or stop the commission of those crimes. And as my co-counsel will explain now, Lord Blaze could not have been in a position to prevent the commission of the crimes if he did not know that crimes against humanity of enslavement specifically were taking place. Unless I can be of further assistance, these are my submissions.
Thank you, Mr. Lubner. I will be making 2 overarching submissions to the courts. Firstly, that Lord Blaze has been tried of substantially the same conduct by a national court. And secondly, that in any event, Lord Blaze does not bear criminal responsibility. This brings me on to my first submission, which is that Lord Blaze has been tried of the same conduct before a competent national court, and therefore this court has no jurisdiction to try him. I would stress at the outset that if the court is with us on this point, then the entire case against Lord Blaze must fall away. I have 3 points to make under this submission. The first is to clarify that this amnesty procedure is a trial for the purposes of the Rome Statutes. The second is to show that the amnesty deals with the same conduct. And the final point is to show that this amnesty is not a sham. This brings me on to my first point, which is that the amnesty procedure is a trial. It is accepted that in order to benefit from the protection provided by Article 17, there must be specifically a trial undertaken nationally. But it is the defence's submission that this amnesty procedure can be considered a trial if you take a purposive reading of the Rome Statutes. That is specifically because the framers of the Rome Statutes elected explicitly not to exclude amnesties in the wording of the statutes. This was something discussed at the Rome Conference, and it was deliberately excluded, or rather a prohibition was deliberately excluded. This was not an oversight. This court cannot defy the will of the Rome Conference and the Rome Statutes. As one of the learned judges has said, this is a treaty court. Secondly, the decision on the lack of jurisdiction in the case of Maurice Calonne is clear that no norm against amnesties has crystallized in international law. And finally, and contrary to the submissions of the prosecution, customary international law is increasingly accepting of amnesties. The United Nations has accepted and ratified amnesties recently, including the Abidjan and the Lomé agreements. It is therefore the case that there is no concrete rule against amnesties being considered a trial for the purposes of the Rome Statutes, and they should be considered on a case-by-case basis. And a proper assessment of the amnesty before this court dictates that it should be considered a trial. International jurisprudence, especially in the International Court of Human Rights, has been particularly active on the question of what is or isn't a trial. In short, a trial can be a wide range of administrative decision-making processes, such as this amnesty, and is not limited to the typical adversarial procedure that a common law jurisdiction might recognize, or that the prosecution have suggested is the only sufficient type of procedure to be considered a trial for the Rome Statutes. Nor is this amnesty before the court some extraordinary measure designed to avoid prosecution purely for Lord Blaze or members of one side of the conflict. Prosecutions were contemplated. The amnesty procedure dictates that if you refuse to comply, you could be prosecuted. And this amnesty is not blanket. It applies to both sides of the conflict, both the AANG and the central government of the fire nation. It is therefore the case that this amnesty was subject to judicial oversight. It contemplated prosecutions, and it had a set of formal requirements that people like Lord Blaze had to conform to. Also, briefly, given the evidence that this court has before it, there is no evidence submitted by the prosecution that there was any procedural defect in this amnesty. And therefore, this amnesty can be considered a trial for the purposes of the Rome Statutes. As such, this court has no jurisdiction, provided that the amnesty covers substantially the same conduct. This brings me on to my next point, which is simply that this amnesty clearly does cover the same conduct as contemplated by this prosecution. This does not appear to be particularly controversial, and I will not labour this point. Simply, that amnesty addresses the mistreatment or alleged mistreatment of Earthblower people and Lord Blaze's part in it. For my final point under this submission, it is clear that this amnesty conforms with the norms of due process and is not a sham. As I have already said, this amnesty applied to both sides of the conflict. It involved judicial oversight, and there were a set of procedural requirements that participants in the amnesty procedure had to conform to. It is therefore capable of being considered a trial for the purposes of the Rome Statutes. As such, this court has no jurisdiction, and this prosecution must fall away.
Counsel, sorry, before you move on, I'm wondering whether or not the first and the second point you have made regarding the trial and the same conduct are intrinsically interlinked. Because for us to determine whether the suspect standing before us, Lord Blaze in this case, has already been tried, we would have to determine whether he has been tried for the same conduct. And wouldn't then that be a requirement for some procedure to be a proper trial, that it actually gives us clarity on what conduct was tried and assessed properly? And the terms you used, forgive me if I forgot them, these very general and broad terms on mistreatment of Earth Bowers, that does not, to me, appear to suffice any standards for clarity as to the same conduct test. So could you please expand on that a bit and clarify that relation between what it takes to be a trial proper and whether that is linked to the same conduct test, and what actually is the same conduct precisely here?
Well, if I may respond with two effectively alternative submissions. Obviously, in the first instance, the defence does not concede that the Earth Bowers were subject to anything more than what you might call mistreatment, and that the conduct they were subject to is a crime against humanity, and therefore that element of the question to an extent falls away. But if the court is not with us on that point, and it is accepted that someone subjected Earth Bowers to what amounted to crimes against humanity, it is submitted that an apology, which was required and given, links this trial procedure or amnesty procedure to the relevant conduct that this court is discussing. Because in order to apologise for something properly, it is naturally included in that apology that you admit guilt. So given what my learned friend has already addressed this court on that this amnesty procedure has clearly been essential to the peace process and actually been instrumental in establishing peace, while we accept that the apology may not directly address point by point every allegation Lord Blaze is subject to, it is our submission that the fact that he apologised wraps up any sort of conduct that he has been accused of in that apology, if to the extent that he is not apologising for crimes against humanity, but he is apologising for whatever members of his government did with or without his knowledge. If that satisfies your question, I'll move on to the second part of my submission, as I'm conscious of time.
Yes, please.
My second submission is that effectively Lord Blaze lacked the mens rea to commit this crime against humanity. We accept the prosecution's submission that the standard here is lower than at trial, but we do not accept that there is a reasonable conclusion to be drawn that suggests that Lord Blaze was aware specifically of the crime against humanity of enslavement. We accept that he knew potentially of overcrowding and unsafe conditions, but that is not the same thing as knowledge of slavery. This appears to be a fatal misunderstanding that the prosecution has made. The prosecution have elected to try Lord Blaze for enslavement specifically as a crime against humanity, and they need to show some reasonable evidence that suggests he was aware of enslavement. One of the learned judges asked a question that raised this point, and it's effectively that having a prison system in a poor state where there may be overcrowding or perhaps harsh treatment is not the same thing as slavery. And it is our submission that the only evidence provided, Exhibits 1 and 2, suggests that Lord Blaze may have been aware or consciously disregarded that his prisons were in perhaps a less than ideal state, but there is no evidence to suggest he was aware of enslavement. To address specifically the prosecution's focus on the point that he was asked for more men, there is no clarity whatsoever that what that question meant was we need more men in terms of guards for this prison because it's getting out of hand and we need to improve conditions. And I would also briefly draw the court's attention to the question Lord Blaze asked in that Exhibit 1, where he says, have the terrorists been arrested? It is clear, therefore, that while Lord Blaze may have been aware in his own mind that terrorists were in prison in conditions that are, we accept, less than ideal, that is not the same of having knowledge or consciously disregarding knowledge of enslavement. It is therefore the case that the prosecution have effectively failed to make out the mens rea for the crime with which they have charged Lord Blaze. Lord Blaze did not know that people were enslaved. He just knew that people, perhaps large numbers of people, were in prison, but that is not the same thing as knowledge of slavery. I'm very conscious of time, but to advance that point slightly further, it is submitted that if the court is not with us on that point, Lord Blaze submitted this matter to a competent authority, specifically the authority represented by...
Sorry, I think your time is almost over. Could you just finish, please?
Okay.
Briefly.
To summarize, if the court is with us on either of the submissions I've made, either that the amnesty is a trial or that Lord Blaze lacked the mens rea for the offence with which he is charged, the prosecution must fall away and fail, because both of those elements are essential to this prosecution. Thank you.
Thank you very much. So this concludes the submission of the parties. I will now give the floor to the prosecution for their 5-minute rebuttal. Please proceed.
Thank you, Your Honors. I'll try to resume my submission in 2 main points. Then afterwards, my co-counsel will continue. In regarding to amnesty, I want to remember that law number 14 that determined that is simply to verify the disarmament and a public apology. In Article 1 of that same law terminated all proceedings and revoked sanctions. There is no judicial procedure conducted against Dr. Blaze. In this regard, I want to call your attention to the point of admissibility. Defense argued that prosecution was saying that amnesties do not help. We're here to address the individual criminal responsibility of Lord Blaze, not the amnesty in general. And the defense also disregarded all the submissions that the prosecution did in regard to the Inter-American Court of Human Rights, which they say it is a principle, an established principle, to prosecute and punish the responsibles of great crimes, crimes against humanity and war crimes. It is as well consistent with the preamble of the Rome Statute and with the interpretation within its articles. In regarding to the contextual elements that the defense argued, I want to call the attention on one point. They disregarded the definition of enslavement, and the definition of enslavement is consistent in Kunarak et al., in both in Kunarak et al., in Taylor's case, in Dominic Ongwen's case, and it has been established, and it is consistent in it to say that all the rights of ownership, that it is all the powers attached to the right of ownership, and that defines an objective criteria. Your Honors, regarding and recalling for a second the question addressed by Your Honors, there is in the position of this objective criteria that the prosecution has submitted the 7 indicia, which are completely fulfilled in the case and from which the defense did not argue against. In all of these indicia, which is established in different courts, it is applicable in the proceedings and in the facts that we address today. I want to pay attention to one case that quoted by the defense, which was the Taylor case, in which they argued that there was a narrow prosecutorial position. And I want to address as well 2 situations. One, that there were 100,000 prisoners in Centerville, and that is reflective of a modus operandi, that is reflective of a widespread attack, and that is reflective of the exercise of all the powers attached to the right of ownership. The key question here is to ask ourselves whether the persons inside Rick Center were given the choice to work or not to work. Your Honors, I want to remember in this case, like in this place, the case law of Croniel Yak, the trial chamber of the ICTY, which was reaffirmed by the appeals chamber in paragraph 191 and 197, in which from the facts, prisoners inside the dome, and for the conditions in which they were brought, they were given no other choice but to comply. I want to address as well that this choice was also not given to the earth powers in the dome. I want to give the floor to my co-counsel.
Thank you, Your Honors. I will just conclude our rebuttal. I want to summarize, address my learned friend's comments regarding evidence. I appreciate, as we've discussed and we've heard throughout these submissions, that this case isn't one, and we concede that there isn't a significant amount of direct evidence in this case. However, we don't think that that should prevent the court from moving ahead and seeing justice. I specifically want to address his comments on the lack of corroboration with Haru Rock's testimony. And I want to draw your attention to the Salavici case from the ICTY, where at paragraph 594, the tribunal found that there is no need for corroboration of witness testimony. It said, as a general principle, the trial chamber has attached probative value to the testimony of each witness and exhibit according to its relevance and credibility. The trial chamber notes the finding in the Tadish judgment that corroboration of evidence is not a customary rule of international law, and as such should not be ordinarily required of the International Tribunal. And Your Honors, it's our respectful submission that it is for the trial chamber to make those determinations of reliability and credibility. Furthermore, we suggest that there is a significant amount of corroborating evidence, circumstantial evidence in this case. Not only do we have Haru Rock's testimony, we have testimonies of the families, we have the exhibits that are before the court, as well as the public NGO report supported by the footage. And cumulatively, we respectfully submit that this circumstantial evidence all meets the threshold of reasonable grounds to believe that is required in this case. Subject to any questions, Your Honors, those are our submissions and rebuttal.
Okay, thank you very much. I will now give the floor to the defense. Thank you.
Thank you very much. With the greatest respect, the prosecution, it seems, have, in our view, effectively missed the point when it comes to the key issue in this prosecution. The detention or knowledge of the detention of Earthbowers, even on a massive scale, does not mean that Lord Blaze was aware of the slavery element of that detention. And the prosecution has elected to charge Lord Blaze with the crime against humanity of slavery. They therefore need to make out that mens rea. And as the prosecution helpfully pointed out, the mens rea of slavery requires knowledge specifically of that slavery. And while we accept there may be a lower threshold at the pre-trial stage to prove that knowledge than there is at the trial stage, it is our submission that absolutely no evidence, circumstantial or otherwise, has been presented that indicates Lord Blaze was aware of slavery. One of the learned judge's insightful questions raises a key issue on this point. The Earthbowers may have been subject to grossly inhumane treatment, but the Fire Nation itself is not on trial here. Lord Blaze is, and they cannot, as in the prosecution, cannot present evidence that he was aware of grossly inhumane treatment that amounts to enslavement. In this rebuttal, or the prosecution's rebuttal, they addressed circumstantial evidence of large numbers of Earthbowers being kept in poor conditions and so on. But that circumstantial evidence does not speak to Lord Blaze's mens rea. In fact, no evidence speaks to Lord Blaze's mens rea, we submit, the prosecution has provided. In fact, the prosecution raised the Bemba case, and they said that that knowledge, the mens rea, can effectively be inferred from contextual information. But the defense's question is, how can such knowledge be inferred here? And it's our submission that it can't. By any standard, you can lower the standard as far as you like. There is no reasonable conclusion on the evidence before this court that Lord Blaze has the required mens rea. Even if the defense, which we obviously don't agree, but even if the defense loses on every other ground, if Lord Blaze cannot be criminally responsible for the crime of humanity against enslavement, this whole prosecution must fail. That brings me to my second rebuttal, which is effectively a rebuttal to a rebuttal. The courts or the prosecution address international jurisprudence on amnesties. They seem to submit that amnesties are effectively, to speak candidly, out. They're no longer allowed in terms of stopping international prosecutions. It is the case, and the defense have submitted the Maurice Colon case. It is explicit in the pre-trial decision on jurisdiction in that case, that no norm against amnesties has crystallized in international law. That is a decision of this court, the International Criminal Courts. The decisions of other international tribunals, while of persuasive weight, do not defeat the decision of a pre-trial chamber of the International Criminal Court when it comes to precedents. And therefore, it is simply the case that no norm has crystallized against amnesties when it comes to Article 17. And as such, amnesties need to be considered on a case-by-case basis. I and the defence were obviously pressed for time when it came to that submission, and one of the learned judges did ask a question that raised the issue of whether or not that amnesty covered substantially the same conduct. It is submitted that when you consider the preamble to the Rome Statute and the purpose of this court, which is effectively to serve the interest of justice, that amnesty procedure may not have been an airtight legal battle between two equally armed adversaries. However, it was judicially overseen. If Lord Blaze refused to comply with it, he could have been prosecuted, because that is obviously the logical conclusion of an amnesty waiving prosecutions. There's no point including that element if there weren't prosecutions contemplated. And as such, the amnesty contemplates prosecuting people if they refuse to comply. And fundamentally, to address the issue of complementarity, if this court refuses to consider that amnesty procedure as valid, they trample on the sovereignty of the Fire Nation, and they risk offending effectively the sovereignty of every signatory to the treaty, because no nation can therefore be confident that their own national procedures will be respected. Thank you.
Thank you very much. The chamber will now retire for deliberations.
While the judges will be moved to the deliberation room, the teams will be moved to different breakout sessions. The judges shall be back in a minute.
Okay, so we will now give you some feedback first of all, and then we will announce the winner, okay? So I don't know, Peter, Julia, I don't know if you want to give some feedback to the teams. Peter, your mic, okay.
You want, yeah. I want to compliment everyone who made his submissions, both on to both of you on the behalf of the prosecution who I'd seen previously, and on behalf of the defense. You were very good in terms of your time management, notwithstanding the intervention of the bench from time to time. You answered the questions well, and you obviously took your time to make sure that you answered it. The one thing I can say for whoever moves forward, I know you don't know yet. When you get a question, wait till the question is finished, then answer it, and don't try to avoid it, but try and answer it as succinctly as possible, because for you, time is of the essence. Particularly in this format, you've got 25 minutes, and you got to make sure that, notwithstanding the interventions, you can make all your key points. From the point of view of the submissions, there was a different approach. The prosecution tended to emphasize more on the law, whereas the defense emphasized the facts properly, or the absence of the facts. And depending on where the judge comes from, if you come from a continental system, you like law. If you come from a common law system, you like facts. We used to say in Canada, if you give me a case with good law, I'll take it. But if you give me a case with good facts, I'll definitely take it, because good facts win the day all the time, or most of the time. So bear that in mind. Know your bench, whoever the final bench is. That may give you an indication as to how you should prepare. And I think it's pretty well continental system judges, from what I can see. But a job well done, and I wish the winning team well moving forward. I hope you enjoyed the experience as much as the judges have. We sort of enjoyed listening to you, and wish you well both in this competition and in the future in your careers. Hopefully in international law, but it's a small playing field that doesn't have as many players as doing criminal law in your home country. But thanks very much, and I enjoyed being part of this bench.
Well, I can only join my colleague in congratulating all of you. It was really wonderful to hear all of your arguments, to have a debate with you. That is, for me, of course, judges are different, moot court judges, but for me, having at least some debate elements in such a moot court session, that is key, because you can expect to the judges to know your submissions, essentially, to know what the case is about, to have read the case. And the oral rounds should really be a place for you to try and dare and exercise some professional creativity, if I may call it like that, to be creative in structuring your presentation, in picking the very strongest points you have, and then maybe having a list at hand with the second most, third most, fourth most strongest points in case you get questions. But just to focus on what can really bring the case home for you and your side, what you're representing here. So that I would really suggest to all of you to take along here and focus on even stronger. Also, all of you did that to a certain extent. And then another point would be, it depends on how long we all will be stuck in this Zoom format with all those small windows. I myself, back then in 2015, had the pleasure of mooting in the real courtroom 600. And there it would have been much more obvious had I just read my script. So I just had something like moderation cards back then to not stand at the lectern and read paper after paper. But even here in Zoom, as I judge, I feel I have a certain sense of when someone is reading out from the screen or speaking freely. So that is something you might also want to take into account because you don't know it if no one tells you. So it's not a stealth mode, it's visible to a certain extent. And that counts into our assessment, of course, as well. So, but other than that, to me, that is feedback on a really high level because I think it was a pleading on a really high level in its entirety. So thanks from my side and best wishes for wherever you may end up practicing or doing law in academics. And have a great rest of the competition.
Okay, so yeah, congratulations to both teams. We really liked this hearing. We enjoyed a lot. Both teams, you were easy to follow. You were clear and structured. So thank you very much for that. Unfortunately, we have to say now, we got to decide who is the winner here. So, but first of all, I would like to say that, yeah, congratulations, and you did a great job. So the winner is the defense team. Congratulations, and good luck with the rest of the competition. Congratulations again.
Thank you very much, and thank you for all of your time. We really appreciate it.
Thank you very much as well. We appreciate it a lot.
Thank you as well. We really enjoyed the contest.
And congratulations.
Very much also from our side. Thank you to our judges. Thank you to the participants, and good luck for the team proceeding further. Then I will stop the live stream here.